Johnny Depp's lawyer, Ben Chu, is not at all impressed with these amicus briefs. So we're going to take a look at the opposition that he has filed, where he is asking the Court of Appeals to reject them. Let's take a look. So the first thing that jumps out from this opposition is a real emphasis on formal correctness. And one of the big signifiers for this, the first thing that I see that jumps out at me is the use of this term omnibus to describe the opposition, characterization. Now, omnibus is it's a Latin word. It means for all. In the legal context, what it means is that you're basically consolidating a bunch of separate issues into one filing. And Johnny has emphasized this formality by dropping in this explanatory footnote to explain the reason why he is filing this as an omnibus opposition, because he is responding to both of the Amicus Curiae motions in this one single opposition, rather than filing separate ones. He's also signposting to the court that I have the same objections to both of them, so I'm not going to just file duplicative briefs on these. Characterizing it as an omnibus opposition and explaining why an omnibus response is appropriate in this case is putting things on this very procedurally formalistic type of footing. Another kind of tell is just his opening sentence here. It goes on, because he names all the parties and stuff. So I'm not going to read the whole thing, but this opening of appellee John C. Depp II, in parentheses, Mr. Depp, meaning that's how we're going to refer to him throughout this brief, by and through his undersigned counsel, respectfully submits his omnibus opposition. This is not the most formal of the opening language that you will often see in kind of old school types of legal writing. I'd say the more common one is the comes now in all caps. If you see comes now, appellee John C. Depp, parentheses, Mr. Depp. Then you are dealing with somebody who is either a little bit old school or is trying to give that vibe, or maybe has ripped off, forms from somebody who practiced, 50 years ago. So this is a toned down version of that, but it still gives us that same type of feel of, oh, we are in a formal setting now. This is a formal pleading. There is a reason why he did that. And that is because he is using that as a kind of cover to be able to say what he really thinks. This is a little bit of a risky move, but we see exactly what he's getting at right here on page 2 with his opening statement. This is a kitchen sink appeal. So you can, to some extent, by being extremely formally proper, going through all of the right motions, using the correct decorum, you can get away with being a little bit more direct, speaking with a little more candor than you might otherwise be able to do if your overall presentation is more casual. And so this is my reading of where Ben Chu is going with this. He is putting on all of the proprieties so that he can say things like characterizing the appeal as a kitchen sink. Now, I understand why he's doing this, because he does, in fact, see the case this way. It is just a little bit of a risky strategy, though, with the Court of Appeals, because the problem is that Ben Chu is dealing with, 5 years, 6 years of accumulated just grievance, difficulty, annoyance. I mean, God, Elaine alone for like 3 years, he had to deal with all of that. So he's had a lot of time to build up antipathy towards Amber Heard's team and her strategies and just the overall approach that she has taken to the case. But the problem is this case is still shiny and new to the Court of Appeals. They don't have that same history with it with you that you do. They don't have the same kind of immediate understanding of what's going on, who the parties are. They don't have the sense for all that yet. So he is kind of asking a lot for them to just jump right on board with his characterization. So that is one way where the appeal process, can be a little bit different from the trial process in terms of what they respond to. I don't know if this is going to be particularly effective just because they don't have the history of seeing the type of nonsense that Amber Heard and her team has been engaging with over the entire course of this lawsuit. Page 2 of this opposition really gives us a lot to kind of convey the overall sense of what Ben Chu's opposition consists of. And so I'm just going to point out a couple of the things here that stand out. First off, this pointing to the highly respected natures of the chief judges, Bruce White and Penny Azcarate, which is fine to nod at them as chief judges. But it's another one where, again, I don't know that this is really effective. He's clearly trying to pitch this as Amber Heard is being disrespectful to these judges. And while, again, having the background in the case, I can understand where he would come to that conclusion. The Court of Appeals is not going to necessarily be starting from that same position. So the fact that they are respected judges, of course, does not mean that they cannot make legal mistakes that would entitle somebody to relief on appeal. Nor does it mean that, they shouldn't be entitled to appeal and to raise every error that they have a good faith basis to believe gives them some type of entitlement to relief. Obviously, Ben is going to disagree with them about what they think they're entitled to. But overall, I don't know that this is necessarily a particularly persuasive approach to try to kind of bolster the judges by reputation in order to insulate their rulings. Now, yes, I've said many times on this channel, judges are human, judges behave like humans, and you don't just, sort of lose all those things when you put on a black robe. And it's very likely that these judges know each other. It's not a very large universe in, the judicial courts of Virginia. There's only so many of them. They deal with a lot of the same people because judges in Virginia are appointed. They very likely move in similar circles. We saw during the trial, Judge Azcarate had to leave for a judicial training. This is very common in many states where judges have these, annual just conferences that they go to and talk about judge things. So yeah, it is kind of expected that they know each other and that the judges on the Court of Appeals may very well know Judge White and Judge Azcarate and have opinions about them. And I'm not even going to say that won't have any influence on the appeal because it might, judges being human. And by that, I just mean that if they have a high opinion of these judges, they may be more likely to give them the benefit of the doubt when it comes to certain types of discretionary decisions. But otherwise, it's not something that really obviously isn't explicitly going to factor into their consideration. So as a focus, this doesn't give them anything to hang their hat on if they want to deny the amicus motion. They can't say, well, no, obviously Judge White and Judge Azcarate are highly respected and this appeal is bullshit, so we're not going to accept the amicus briefs. That's kind of the issue that I have with it. It might work on this kind of subliminal level, but it's not going to be something that the court could actually acknowledge and base a ruling on. Another thing in this first page that catches my attention here is the use of these italics. He uses italics and underlining for emphasis. This is something that way back, many years ago, when I clerked at the Court of Appeals, I learned immediately that if you have to emphasize your words to make your point, it's because you're not explaining what the problem is. I don't like seeing this in an opposition because, yes, he's signaling that he feels very strongly about it, but it's going to be more persuasive to the court if you simply explain to them why it means so much to you to add this emphasis to it. And then the last thing I'm going to point out here is what I see as a real missed opportunity. And I think, again, this may come down to a little bit of the difference between appellate practice and trial practice. They are different cultures. The Court of Appeals is an ivory tower. It's nerdy. It's like being in the library all the time. They love, old cases, common law, principles, treatises, just the whole academic side of what the law is about. And so in this particular sentence, I think they missed an opportunity here to give the court something that the court would really enjoy and that the court could really rely on. That's this sentence here. Though there are doubtless cases in which briefing by amici curiae might assist the court in resolving the issues before it, this is not one of them. What are those cases, Ben? When is amicus curiae appropriate in a case? When would they be helpful? How can they be helpful? This is really kind of the key to the whole question of whether they should be allowed to participate in this case or not, is what are they there for? And so telling the court just accept that, other situations might be different, this one is distinguishable, you haven't explained to them exactly how and why it was different. It's not that amici curiae can't be allowed if there's private counsel on a case. I mean, that's not the rule at all. It can't be the case that amici curiae shouldn't be allowed if their arguments concern matters of public policy. This is a very commonplace purpose, a reason for amici to participate in a case at all, is to bring those types of things to the court's attention. So this was a chance for somebody to go to the law library and find like an old treatise on how to present your case at the U.S. Supreme Court and find the chapter on amicus curiae briefs and talk about them, what they are for, to find some examples of amicus curiae briefs. A very well-known one is one that is called the Brandeis brief. It was submitted by, later became a justice of the U.S. Supreme Court, Justice Brandeis, and it was kind of one of these first examples of a brief that relied very heavily on sociological type of information to bring that to the court's attention so that they are aware of it as they are considering how they're deciding the legal issues in front of them. That's the type of thing that the court likes. They like citations. They like details. They're not here to just sort of pull the law out of the ether and put it on paper. They are there to pull it from the books and synthesize it. So this was an opportunity to give them a lot of fun, interesting, good stuff from the books. They didn't take that opportunity, and I think that was a missed chance. This introduction is following the style of tell them what you're going to say it, and then tell them you told it. It's a great structural component for persuasive writing. So the introduction here then serves as the synopsis of the opposition. This is what I am going to be telling you, is the basis for not accepting these amicus briefs. So it's a good summary. He explains that first, it's not technically incompliant with the rules that are laid down for what these briefs need to contain and look like. Second, Amber already has her own lawyers. They're perfectly good lawyers. She doesn't need, a backup lawyer to come in and go to bat for her. And it's unfair to Johnny to burden him with having to, be double, triple teamed up on by these folks on Amber Heard's side, because it puts him at a disadvantage in being able to respond. And then lastly, what I consider to be the strongest of the oppositions here, the amici's arguments add nothing to the legal analysis provided by her counsel and appear focused instead on arguing with the jury's clear findings in favor of Mr. Depp on the underlying factual issues. This is where, from my perspective, a fleshing out of the role of amicus is really helpful and possibly even necessary to kind of allow this argument to land. The reason you have amicus briefs, as I talked about in my previous videos, is because when the court's addressing general legal issues that have the potential to have broad impact, they want to hear from the stakeholders. It's expected that the attorney for a party is just going to be litigating for that party. They aren't necessarily going to be thinking about or interested in, the impact on society as a whole. You want the best outcome for your client. And if that means, that maybe it's not so good for other folks later on, that's not your concern. It's not your job. That's for the court to worry about. But so that's where Amicus Curiae come in and fill in that gap by making sure the court is aware, like, hey, yes, this person's personal interests are all fine and good, but you need to look at the bigger picture here and understand the kinds of effects that a decision is going to have. So the real problem with these amicus briefs is that they are acting as friends of Amber, not as friends of the court. They are offering their perspective on issues that are specific to her and to her case. And that's not what amici are there to do. So just for example, one of the complaints in the second amicus brief, they spend time arguing about whether Judge Azcarate should have allowed, other publications that said bad things about Johnny Depp to be admitted at the trial. This is a single ruling in a single lawsuit in a single trial. It has absolutely no impact. It has no precedential value. It has no legal effect on anybody but Johnny Depp and Amber Heard. So there is just no way that an argument can be made that, for example, victims of domestic violence are affected in any way by Judge Azcarate's ruling, not allowing that evidence to be admitted for the reasons that she did. That's the real distinction here, the distinction between they are advocating for Amber, not that they are advocating for the broader society as a whole. We see another example of this radical candor from Ben Chu in this characterization of what is already a sprawling, misplaced appeal, which is kind of fun. And another thing I'm going to point out here that he does, he's using the principle, I think, of primacy and recency. The idea that if you have multiple things to say, the things that people are going to remember are the very first thing and the very last thing. And so that's typically where you want to put your strongest points. You either want to put them at the very beginning or at the very end. And so this final complaint, that he spends an entire paragraph on, that these amicus briefs are not legally helpful in any way whatsoever. I think he is using that to close out his introduction, because he is hoping that's the point that is going to stick with the court. As I've said, certainly my opinion, that is the strongest one. And this particular comment, I think, could have, came all the way up to the very first part of this paragraph here. The briefs offer the court no insight on the legal issues actually at issue in Ms. Heard's appeal. This to me is kind of the key. Remember, we looked at what are they even giving us for the law in these amicus briefs. There is extremely little focus on the law. So yeah, that's a strong point. That just re-emphasizes that the purpose here is not to help clarify the legal context for the court. It is just there to argue about the facts on behalf of Amber Heard. So now we get into the more detailed analysis of the grounds for the objection. He starts off with the technical defects. He is alleging that the amicus briefs have to follow all of the same format requirements as the briefs of the parties do. And so because of that, they have to specifically identify assignments of error that they are focusing on, and they have to reference the record to identify where that issue was preserved. So he's arguing they didn't do those things, therefore the briefs themselves are defective and should not be allowed for that reason. The second thing he argues is that the second brief was in 12-point font instead of 14-point font as is required. I'll take his word for it. I don't know if that's the case or not. But if that is the case, then yeah, that is a formal defect that needs to be corrected or not allowed. Now, I do have a little bit of a complaint with this. It's not that it's bad to point these things out. I don't like that he leads with it because this is not a strong issue. The reason why it's not a strong issue is because mistakes like this are curable. You can just fix it. And the Court of Appeals generally prefers to let people fix little technical mistakes rather than affect what, could be important information, an important opportunity to be heard, simply on the grounds that, well, you didn't do it procedurally the way that you were supposed to. And so we actually see that these Simpson amici that he's referring to have already tried to do this. They've submitted a corrected brief. They've requested leave to file these additional, basically appendices that would satisfy these requirements by identifying the assignments of error and the portions of the record. Now, it's funny in a way, just a real quick sideline here, because this should be a very easy thing to do. The court, you just say, hey, my bad. Here, I'll fix it. And you can go ahead and accept this one instead. Mistakes happen. It's not ideal, but it's not the end of the world. But something about Amber Heard and the kinds of lawyers that I guess she just decides that she has to have. They can't just do that. No, they've got to make it so that you're almost going to make it hard for the court to give you what you're asking for because you're being so obnoxious about it. Where they say, although amici do not believe that assignments of error are required for an amicus brief, they want to quibble over the requirements of the rules and instead of just doing it. So, they want to make it harder for themselves. Whatever. I guess that's going to be whatever it is. But my suspicion is that, yes, the Court of Appeals will allow them to fix these format problems. So this is not a particularly strong opposition. It is not one that I would lead with. It is one that I would probably bury somewhere because it's not going to be dispositive. Next, Ben moves on to the argument that this is basically unfair. Amber Heard doesn't need the help and it's overly burdensome to Johnny. I gotta first compliment him on this header here. Excellent use of the because explanatory here. Appellant is well represented and responding to the amici would unnecessarily burden Mr. Depp. Very clear why you're saying you want the court to reject the briefs. So that I like. I don't necessarily, though, think that this argument lands as well as it could. So he relies on the rule and the fact that leave of the court is required for these types of briefs to be filed at all to say that essentially it's generally not considered necessary. And that is true. That is correct. Amicus participation is not necessary. But again, if you haven't given the court the context of what amicus briefing is for, what the role of amici is supposed to be, and how it is helpful to the court, that is what allows you to put it in such sharp contrast with what the amici are trying to do in this particular case. Whether Amber Heard is represented or not is really not the point at all. I mean, I represent, okay, yeah, I'm a good lawyer, but I'm a public defender, and it's not like my clients are entitled to amicus participation, because they just have some public defender. That's not the thought process. It's a distinction between whose interests are you focused on. The Court of Appeals is focused on the broader interests of society as a whole, not just the particular interests of the parties before them. So I think this could have really landed well had it been clear that this is what amici are supposed to do. Here is what they did. They spent the time litigating these specific issues, dealing with the facts and the evidence that only relate to Amber Heard and her interests. She has her own lawyers to do that. That is their job. That's not the job of amici. So I don't feel that really came through, and I don't know that it necessarily landed. Similarly, they argue that Ms. Heard's counsel appear to be acting in coordination with counsel for the amici. In and of itself, coordination is not a problem. It's normal. It is to be expected. If I'm going to be, going up to the Washington Supreme Court on a particular legal issue, I may work with amici. I may discuss with them about here's where I'm going with this case because of that distinction between I'm focused on my particular client. You guys want to move the law in a particular direction. And yeah, that may be helpful to my client. Often it is. That's why I get amici in those types of cases. But sometimes they don't always line up. And so it's just not that unusual or weird to have these types of conversations about, here's the take I'm going to have on this legal issue, and just kind of put everybody on the same page about what your positions are. They hit the point that is important here. It strongly indicates an attempt by appellant Heard to circumvent the page limits imposed on both parties. Yes, Ben, that is correct. That is what I said in my previous videos. That's the problem here. Because these are not acting as proper amici, they are acting as, the bench for Amber Heard. By the bench, I mean, in baseball, not in the courtroom. They're backup lawyers for her. They are litigating her particular issues. That's the way that it's serving to circumvent the page limits, because it's not giving the court helpful social context or helpful legal analysis. It is just arguing about, the sufficiency of the evidence that Amber Heard was an abusive monster to Johnny Depp, as the jury kind of found. And the final argument in this section is that for Johnny to have to respond to all of this in the 55 pages that he has to file just his response is unfair, because here he is getting triple teamed by all these people on Amber Heard's side. They ultimately bought themselves a total of 148 pages if all of these amicus briefs are allowed to be brought in and considered. So it's not fair for him to have to respond to that in the small amount of space that he has available. Fairness is a very legitimate consideration. It is something that the court is concerned about. Having said that, responding to amici, I don't know what the practice is in Virginia, but what I will say is it's not necessarily automatic. Because amici aren't a party to the case, it's often kind of understood that they are not providing the type of information or the type of argument that it is expected for the opposing party to respond to. Not to say that they can't. So in my state, for example, the common practice would be, if I want to respond to the amicus brief, I would file a motion to the court asking for leave to file a response to the amicus brief, and I would just file a separate brief in response to the amicus brief. Typically, leave is going to be allowed if the court considers the amicus brief helpful, because they are concerned about fairness. So I don't really know what to say about this, because there's nothing in the Virginia appellate rules that specifically provide for a response to the amicus curiae at all. My understanding is that, Virginia is a common law jurisdiction. It's common for things to sort of be done because that's how they've always been done, and it doesn't necessarily get written down. You just have to sort of know what the custom and practice is there. So I don't know what the custom and practice is for responding to amicus curiae briefs in Virginia. That would be helpful to know, but I'm not sure, again, that this is necessarily cast the way that it could be, because if the problem is you don't have enough pages to respond to all of them, were you in Washington, you would just file a motion asking for leave to file a responsive brief. You wouldn't have to try to fit that all into your single response. So it's an argument for unfairness that is kind of in his power to fix. But we'll see. Big pet peeve of mine, having this lonely footer here stuck at the bottom of page 6. I don't like that. Just space it, just reformat that, get that header up to the top of your next page. Small thing, not very important. And again, good structure, using the explanatory because the arguments of the amici are irrelevant and inappropriate. That could be fleshed out a little bit more as well. Instead of just characterizing them as irrelevant and inappropriate, you could say, for example, because the arguments of the amici don't bear on the issues that the court is really being asked to decide, and they don't provide the type of legal or social context that's going to be helpful for the court to consider. Obviously, that was a wordy mouthful that I just gave you, but that's how I would take this particular header and kind of bump that up to a next level type of header, wordsmithing it with that type of thing in mind. So then we have, I'm not going to say this is a missed opportunity again, where he says, Mr. Depp will not address the substance of the amici's arguments in detail in this opposition, which is good. We don't want an in-depth response to the substance of their arguments at this stage of the process. But I do think, again, it would be helpful to spell out a little bit more clearly what your complaint is and provide them with some references. Court of Appeals like citations. They like citations. Give me a page reference to the brief where they're being inappropriate. You could give me a page reference, you could quote a section of it, you could give me an explanatory parenthetical, telling the court this is inappropriate because, and that I think would go a long way towards carrying the weight of showing the court that there is a problem here and not having to rely so heavily on the characterizations of cherry picking, misstating the evidence, relying on their personal factual conclusions. Yeah, I agree with all of these things, but it just isn't so crystal clear to me that the Court of Appeals, coming at this cold without that background, is necessarily going to see that really clearly at this stage. So fleshing that out could have potentially been helpful. Otherwise, though, yeah, strong point, really strong point here. They're just litigating the facts. They're bringing up things that aren't even assignments of error as error. They're litigating her particular interests. It's a bunch of bullshit, Your Honors. Then he moves on to the arguments are wholly inappropriate on appeal. And now we get the references to the law that are pretty much all we're going to get out of Binchu's brief. And again, this to me is a big lost opportunity. This was an opportunity for the kind of nerdy scholarship that people who end up on the Court of Appeals live and breathe for. So instead, we get the court should not substitute its own judgment for that of the jury. Yes, we know that. We get deference to the jury on questions of fact. They get to decide credibility. They get to decide what happened. They get to decide if there's disputes in the evidence, which one is correct, which one is not correct, and the judge isn't going to revisit any of those things. So they're correct that it's not a good argument. Is it an inappropriate one? I mean, people make it all the time. It's just sort of expected. That's just more about it not being helpful. It's not helpful to the court at this posture to go back and try to relitigate the facts. And then the amicis focus on some perceived social harm that will result to abuse victims generally from the verdict is both factually misguided and an inappropriate argument because the jury was tasked with making a factual determination with respect to only the parties to this action, not with sending a message to society at large. And then he cites this Virginia Supreme Court case that is looking at closing arguments and the use of this send a message type of argument that many jurisdictions, probably most, have held is improper. You're not there as a jury to send a message. You are there to apply the law to the facts. And that is what justice consists of. And sometimes the message that is sent from that is not one that people want to hear. This is not persuasive at all. It's just not persuasive at all for a couple of reasons. This is not a closing argument. This is briefing on appeal. And they aren't presenting those issues because they are suggesting that the jury should have considered them. They're presenting the issues because these are the types of things that courts of appeal do consider. They do consider big picture policy issues, and that isn't inappropriate at all for them to do. Now, I very much agree with Ben that the way that they have sort of tried to do that in this case is not particularly effective or helpful. They didn't give us anything that we don't already know, that lots of women are abused and that people are often afraid to report abuse because they fear retaliation. Like, these are very common sense things that you don't need, some organizations and academic professors to tell you. But the general idea of including this type of information in an appellant's an appeal brief is not at all improper. And this, to me, kind of makes it look like Binchu is not in his wheelhouse. He's not comfortable with the appellate process. He maybe has never dealt with amicus briefing before. That really wouldn't surprise me. So it isn't something that he's necessarily all that comfortable or familiar with. But for somebody who has been in the appellate world as their, exclusive focus for an extended length of time, they're going to see that and think, that's not really how that works, though. And so it's not helpful. In his last paragraph here, then he revisits this theme of basically it's unfair to expect Johnny to have to respond to all of this in the limited space that he has. For the reasons I've already said, I don't love this. I don't love this point. It's not clear to me that he's expected or required to respond to the amici in his 55-page brief of appellee. So I think it would have been a little bit better, just in my opinion, of course, to focus on the lack of helpfulness to the court and the way that instead of, it's normal for Binchu. Binchu is focused on his own workload, okay? He knows how much he has to do over, the next several weeks to deal with all of these appeals. So he's very focused on the burden to Johnny Depp, and that's appropriate. But it's not a bad strategy to pitch to the court their own big workloads and what is efficient for them and what is useful for them and what is helpful for them. And I guess I just feel like, in my opinion, that would have been a stronger focus for this type of opposition, to just point out to the court, these aren't helpful. They're not giving you law. They're not adding anything that is above and beyond, what Amber Heard is giving you in her briefing. And so all it is just an effort to try to, add additional pages that are just talking about factual issues. If those aren't going to be dispositive questions for the court anyway, then you just don't need to waste your time on them. He's I don't want to say he's like threatening a back and forth. It's not a threat here, but it just reflects what can be a little bit of a mistake, I think, in litigation, of getting bogged down in rebutting every little detail. And I imagine Ben Chu has a background in debate. I think he probably does, because I get that sort of formal sense from him. He likes to do the first, second, third, type of structure. And that suits him and his argument style. And so that would be very focused on, okay, I need to individually rebut each of the points my arguments, my opponent makes, because that's how you score points in a debate match. But it doesn't work well necessarily in a courtroom, because you just have to have the judgment to recognize what matters and what doesn't. These factual arguments by the amici, for the reasons you already pointed out, are trash. You don't have to address them at all. You can treat the trash like the trash it is and just leave it sitting at the curb for somebody else to deal with. So it's just not the strongest point to suggest to the court, I'm going to have to respond to all of this. No, Ben, you don't have to respond to all of it. You really don't. I give you permission to disregard the stuff that is so stupid, it is not worth anybody wasting any of their time on, because that's what the Court of Appeals is going to do with it. Lots of folks have asked me, when are we going to find out what the court decides on this motion? And unfortunately, we don't know. The way that motions get handled in the appellate courts is typically pretty different than the way they get handled at the trial level. And we have a rule here in Virginia that tells us how motions in the Court of Appeals are handled. It basically just says you file it. The other party has 10 days to respond. These motions are not typically argued, which is very different from the trial court, where pretty much every motion is argued. In the Court of Appeals, they tend to rely on the briefing and not have oral arguments on motions. And then when will it be decided? Well, it will be decided when the judge issues an order. And all we know about that is that once the court does enter an order, the clerk is going to forward it to the parties. So there's no timeline for this thing to be decided. I've seen situations where the court has waited until it's issued its opinion in the case to say, we granted leave, to accept these amicus briefs. So it could be later on. It could be fairly quickly. We really don't know. As I've said before, it is kind of rare for amicus briefs to not be accepted. It's just a courtesy to allow, groups who have something to say about important legal issues to be able to do so. But I do think this might be the rare situation where it doesn't happen, just because the amici have so clearly overstepped their purpose for being there in the first place, that there's a non-zero risk. It's just going to annoy the court and make it seem inappropriate. But by and large, my personal prediction, I think what they're probably going to do is allow them to be filed, but basically either disregard them or discount them. And what we can hope for, as I mentioned in my first video, is the kind of worst case scenario for Amber Heard is that the Court of Appeals actually decides to address these arguments on the merits, because there is so much that they can go in and highlight as to the reasons why the jury found she was not credible, the reasons why the jury found she was the abuser. And for all of those things to be out there in a published precedential decision by the Court of Appeals, I don't think that's really what Amber Heard was thinking she might get when, somebody decided to work on coordinating with these amici to get them to participate on her behalf. So, we all kind of like to see the karmic wheel turn, I have to say. Wouldn't necessarily break my heart if that's the route the Court of Appeals decided to take with these. So if I hear anything about whether they are granted or denied, I will let you know. And in the meantime, we have now gotten Johnny Depp's reply. So we have a full set of briefing on Johnny Depp's appeal, which I am going to be looking at next, and I will see you there.